Texans. Trapped. This website is dedicated to the 2.2 million Texans who are now trapped as second-class citizens, only because they've accepted something called deferred adjudication. Let me explain. Let's say you were arrested in Texas and accused of a crime. You were offered a deal as a first-time offender. They said you could avoid a conviction, earn a second chance at life, if you accept deferred adjudication. So far, over 2 million people have signed this contract with the state of Texas to have their cases dismissed. But now, after the fact, the state is treating these dismissals as convictions. We think this is wrong. We are the San Antonio chapter of the Texas Association of Justice and Legal Reform. Please take the time to view the resources available on this website and see if you agree. Here's how deferred adjudication works. The defendant agrees to plead no contest or guilty to the charge. They agree to a probationary period during which they'll be subjected to random alcohol and drug testing, community service and supervision, counseling, and a nominal fine. Now, if the defendant violates any of the terms of this agreement, they waive their right to a trial and are automatically found guilty and are subject to the maximum penalties allowed by law. In return for this commitment, the state of Texas promises that upon successful completion of a deferred adjudication, the case will be dismissed and the defendant's rights and privileges will be restored. Texas Penal Code is very specific in how it defines the dismissal of a case. A dismissal and discharge under this section may not be deemed a conviction for the purposes of disqualifications or disabilities imposed by law for conviction of an offense. Supreme Court Justice John Paul Stevens explained it best. The whole point of the statute is to avoid having to formally adjudicate the defendant's guilt, unless and until he demonstrates that he cannot abide by the terms of the probation set by the court. If the defendant successfully completes his probation, his offense is essentially expunged. But here's the problem. The state of Texas is treating deferred adjudication as a conviction, so a one-time offense becomes a lifetime of discrimination. Those who accept deferred adjudication now have trouble getting a job, housing, insurance. We think the state of Texas is in breach of contract. The state should not be allowed to treat a successfully completed and dismissed deferred adjudication in the same way as it would treat a person who had been formally and finally convicted. Here are some points to consider as you formulate your opinion on deferred adjudication. Reforming deferred adjudication is not a public safety risk. In fact, a recent Carnegie Mellon University study showed that convicted offenders who have remained clean for 5 years are statistically no more likely to commit an offense than anyone else. Many innocent people accept deferred adjudication just to save on legal expenses and the risk of trial. This hits the poor and minorities especially hard. Non-reform is bad for the economy. Limiting access to jobs increases unemployment, shrinks the taxpayer base, and adds more people to government assistance programs. Deferred adjudication is a contract, and Texas is in default. Do we really want to live in a country where the government can break legally binding contracts at its discretion? We don't think so. If you agree that reforming deferred adjudication is the morally right thing to do, join with us. Register on this website for our newsletter. Tell a friend. Make a small charitable contribution. And make a big difference in the lives of millions of Texans.